So when we get to Karina's turn to present, we'll allow her to introduce herself, but I'll just do a quick lay of the land. So first we've got our generalized legal disclaimer, and then we'll move to the next slide to talk about what topics are we going to talk about today. So there are three main areas we're going to cover. One is compensation. What's happening out there across the state within the public sector when it comes to compensation. Two is what specifically are wage and benefit trends, especially with COVID-19, and maybe we're at the tail end of it. Economy's improved, vaccinations are up. What's that meaning for employers? Then as part of trends, we'll talk about pay equity, which is getting much more of a spotlight, especially with the new administration, and is just practically becoming a much bigger deal with employees. Then three, we thought it'd be a good primer, not only is it a trend, but get back to the basics. Now is the time. We've limped along through COVID, but let's make sure we've got our base pay infrastructure in place. So we'll talk about that in topic two. Topic three then is the legal update on wage and hour issues. So again, we'll cover briefly some of the basics. Then we'll talk about four areas of wage and hour law and what's happening, what should all of you as public employers look out for when it comes to who's exempt and excluded under wage and hour law, what's compensable time worked, what should you be paying for but maybe aren't and is getting a lot more attention. Three is overtime compensation, especially in the public safety sphere. We're seeing a lot more of aggressiveness from employees and unions on that front. Then five, subtopic within that is, what records should you be keeping? It sounds innocuous, but it becomes a big deal legally. And then we'll end, if time permitting, with Q&As. So then the next slide, as usual with our webinars, if you do have any questions, you should submit those via the chat feature within Zoom, which on my screen at least is in the bottom middle. You just click the chat button, you'll send a question. So we'll do two things with that. One, we'll try to keep up with it electronically and submit a written response, and or two, we will attempt to weave in, answer those questions and what those answers are verbally for all of you as presenters. And as we'll end with, as usual with these webinars, not only the webinar itself, but the PowerPoint slides will be submitted to you and accessible online. So with that introduction, I'll hand it over to Karina to cover the first substantive topic.
Hi, good morning. So as Brandon mentioned, my name is Karina Patino. I am the firm's legal analyst, and I provide jobs classification and compensation services to local governments and public entities. So as Brandon mentioned, we're going to be going over a couple of topics. So one of the things that we're going to be doing is asking you, the audience, a couple of questions to make this a fun and interactive experience. So our first question for you is, what type of local government do you represent? Are you a city, a county, a utility, a private entity, or other? So I'll give you some time to respond to that. So it looks like a majority of you are city, about 76%, county at 13%, and then we have utility with 3%, and then other entity for 8%. So welcome, everyone. So the first topic we're going to be going over are our compensation update. More specifically, we're going to be looking at the state's local government wage increases and ranges for the years of 2020 through 2022. So specifically looking at the settlement increases. So for 2020, we are seeing an average settlement for before March 1st, 2020, 2.83% with 144 entities. And it looks like the majority of entities had a 3% increase with 83. And then we also had 59 entities who reported a range of 2 to 2.99%. And for post March 1st, we have an average of 2.68%. Majority provided a 3% increase. And then we have our total average of 2.82% for a total of 158 entities. So one thing to note is that this is these following charts just include our wage settlement increases. It does not include any additional steps or performance pay that may be included. For 2021, we saw a total average of 2.65%. Breaking that down to before March 1st, we had an average of 2.77%. With a slight change between 2020 and 2021, we saw a majority of increases between 3%, and then our post March 1st, we saw 2.48%, with the majority being in 2 to 2.99% increases. And then again, the majority for the total average was actually 3%. For 2022, we saw a pre-March 1st of average of 2.66%, with a change of 3% being the majority for before March 1st. And then for post-March 1st, we saw a total average of 2.51%, with the majority actually being anywhere from 2 to 2.99% of an increase provided, with a total average of 2.59%. So one thing to note as we went through these slides is that we saw that COVID-19 had a short-term impact on the average settlements that were provided by entities to their employees. Now we're actually seeing that the settlement increases are starting to go back up now that we have a better economy and we have better finances. So we're seeing that a lot of entities are actually looking into getting market wage analysis so that they can maintain their competitive edge. So following here, we are going to be looking at arbitration awards. So for 3 years of 2020 through 2022, 2020, we saw a total of 9 awards with a union proposed increase of 2.93%. The employer proposed a 2.41%, and the arbitrator award average was 2.52% with a award range of 2 to 3%. For 2021, we saw 6 interest arbitration awards. A union proposed 2.83%. Employer proposed a 2%, and the average award was 2.33 with a range of 2 to 2.5%. For 2022, so far, we've only seen 2 awards that affected 2022, and the union increase was 2.63% as a proposal. The employer proposed a 1.25%, and the arbitrator award was an average of 2.63 with a range of 2.5 to 2.75%. Now we're going to be looking at health insurance contributions for 2020 and 2021. So based on cities, we are seeing that for a single plan, city contributions are at 91.84% for 2020, and the family is at 81.3%. And 2021, we are seeing 85.04% for single, and then a family plan at 83.54%. So our next topic will be wage and benefit trends. So we're going to be looking specifically at total rewards. So what are total rewards? Total rewards are the tools that are used to attract, motivate, and retain employees. This includes everything that the employee perceives to be a value resulting from the employment relationship. So this is a compensation, any benefits, work-life effectiveness, recognition, performance management, and talent development. So here's another question for you. Has your organization altered or adapted their total rewards package due to the impacts of COVID-19? So if you can answer yes or no. So the majority listed that no, 80% did not alter their total reward package, and 20% listed that they did alter that package. So one of the things that we're seeing when it comes to total rewards is that we're seeing a lot of employees are customizing the reward package for their employee group type. So every employer or organization has different types of employees, and every employee is at a different stage in their life. So they may have been impacted by the pandemic in different ways. So one of the things to do is that they need to ensure that you are offering benefits that are appealing to the type of employee that the organization wants to recruit. So the most important thing that an employer can do is obtain that information or get that employee input, and that can be done by either pulling through a survey or just sending some sort of a questionnaire for them to fill out. So that way the employer can know what benefits they need to invest to ensure that those are the most important to employees, and allocating those benefit dollars to the programs that are most meaningful to the organization to the employees in the organization. So the important for this is that employers need to understand what employees need and want from a total reward package. They need to maintain this perspective in order to maintain their competitive edge among other employers. So according to RSM, total rewards is the #1 thing that employees are looking at. So to maintain that competitive edge, employers must evolve to meet the needs and wants of that new post-work environment. So that can be done by offering low-cost yet high-effective benefits such as flexible work schedules and work-from-home options. So one of the work-from-home options that you could possibly implement would be a hybrid work schedule where an employee has the ability to work from home a couple of days a week and then going into the office for the remainder. So workers are expecting more for their employers. So this is a trend that we're seeing. So organizations should evaluate the strategies that they're utilizing to attract, retain, and reward their employees. So according to RSM, work from home options have been proven to equally or more have the employee become productive more than your traditional office work schedule. So we're going to be discussing pay equity. So as many of you know, pay equity, the state of Minnesota established the Local Government Pay Equity Act, which serves to eliminate sex-based wage disparities in public employment in the state of Minnesota. And pay equity law in Minnesota only addresses gender-based wage disparities, so it does not look at any other type of wage disparities. It also facilitates the compliance with other anti-discrimination laws. So what is needed for an employer in order for you to have a successful pay equity system? So you need to have a uniform job evaluation method to effectively review all of your positions within the organization. You need to assign points utilizing Minnesota's pay equity law method, and that is done by reviewing the factors of skill, effort, responsibility, and working conditions. So the employer needs to adjust salaries if they are consistently paying males more than women for the performance of the job with similar points. And then finally, the state of Minnesota requires for all political subdivisions to submit a pay equity report every 3 years. So why is reporting important? So this process examines the local government pay structures for evidence in gender inequality and works to assist organizations in achieving pay equity compliance. So what does the reporting process look like? So there are 5 tests that MMB performs depending on the information that is reported. So that's the alternative analysis test, the completeness and accuracy test, the exceptional service pay test, salary range test, and the statistical analysis test. So the purpose is to review and determine the entity has established adequate compensation and relationships. So cities with 3 or fewer male classes or 4 to 5 male classes with an underpayment ratio of 80% or no classes with a salary range and an underpayment ratio below 80% will need to only pass that alternative analysis test. All other cities will be required to pass a statistical analysis test. So the salary range test is only required for cities that have a system where there's an established number of years to move through those salary ranges. And then an exceptional service test is only required for cities that have a system that include that exceptional service pay. So as we've discussed a little bit about job evaluation and the analysis that's needed to be compliant for pay equity, those are 2 main factors that go into the development of a base pay structure for an organization. So here's the question. Do you have a uniform base pay structure covering all employees or certain large employee groups? So majority of you answered with yes, 96% have a uniform base pay structure and 4% do not have a uniform base pay structure. So what do we need to look at when establishing employee compensation? So when establishing compensation, employers need to ensure that each job within the organization interrelates with one another. Compensation must optimize the achievement of the employer's mission, goals, objectives, and determine the relative worth and appropriate pay rate, other pay, and benefits for the job. So other pay would be premium pay above regular wages or salary for doing additional work and additional hours. So what is considered compensation? Compensation establishes a standard of living for employees and primarily indication of the value the employer places on a position within the organization. So what are the different types of compensation systems available? So first thing we need to look at is what a compensation system establishes. And that's essentially how the organization manages compensating employees. That means any wages or salary paid to the employee as a base pay, any variable pay or form of short or long-term incentives such as promotions and performance pay increases, and that other type of pay such as premiums above that regular wage, and any monetary value of benefits. So employers must consider the total reward package when establishing employee compensation, again, to maintain their equity and also their competitive edge. So when establishing a compensation system, we'll also need to look at job analysis. So job analysis is the systematic process for obtaining important yet relevant information about each distinct role played by one or more employees. We'll be looking at positions' duties, responsibilities, the required work characteristics, and which are particularly important in establishing compensation. The information that is used for this phase is needed to accurately review the position's worth internally and externally, and then ultimately build the organization's base pay structure and assist with the drafting of job descriptions. The job analysis phase, all that information that is gathered is also utilized to determine the position's Fair Labor Standards Act exempt status and language that will be needed to include it in the job description. So here's a question for you. Approximately how long ago have you conducted a comprehensive job analysis of all or most jobs in your organization? 0 to 5 years, 6 to 10 years, or 10 plus years? Okay, so the majority said 0 to 5 years at 62%, 6 to 10 years with 18%, and then 10 plus years at 20%. So as we mentioned, the job analysis is essentially the primary source in order for us to evaluate the position's duties, responsibilities, and required characteristics of the position. So it's very important when it comes to creating the compensation system. However, job evaluation is also another important next step. So the first step is job analysis, and this following step would be job evaluation. So what is job evaluation? It is the systematic method and process for determining and comparing the relative value of one job to others. It develops the internal standards and comparisons and measures relative to job worth within the organization, and it enables the creation of job worth hierarchy within the organization. And as we'll go on to the presentation, we'll be able to explain why that hierarchy is very important when it comes to not only developing your base pay structure, but also for pay equity purposes. So why conduct the job evaluation? It establishes that comparison using internal and external methods. It determines the value of work that is performed by each class. And then, as I mentioned, for pay equity reporting purposes. So for pay equity, all jobs must be evaluated and given points according to the level of knowledge and that responsibility required to perform the job. The value of work must be measured by skill, effort, responsibility, and working conditions. Skill measures the education, experience, or training that might be required of an individual to perform the job. Effort is a mental exertion that's required of the individual. Responsibility, so the degree of accountability that an individual will be held for while performing the essential functions of the job. And then working conditions, specifically at the type of physical abilities that are required of the individual, and then any elements that an individual might be exposed to while performing those essential functions. And then the pay equity also requires that each jurisdiction measure their positions, not only internal, but also their external worth. And then it also helps determine the appropriate pay rate and the job worth. So now that we've gone through our analysis and our evaluation, we also want to go over how important it is to review external comparable sources. So market studies should be conducted routinely at least every few years to make updates to your base pay structure to ensure that you're taking into account the market when it comes to your internal equity. So the types of data that can be collected in these types of market studies are either internal, which is other entities that are most similar to you. So that that can be a city, a county, utility. External would be Minnesota DEED, LMC, or MMUA data. So all of this would be depending on if there is a specific position that you want to target, or if there is a group that you want to target, or if just generally you're going to be obtaining information for your whole organization overall. So it's important to compile and analyze this type of market data so that you can see the market pay rates and utilize those for the development of the organization's base pay structure. So this will help employers to modernize their total rewards program, effectively retain and recruit employees. So again, maintaining that competitive edge among other employers. So now the next step would be the actual creation of the base pay structure. So employers should consider establishing a uniform base pay structure that includes all employees or large subgroups of employees. Generally, we recommend that a uniform base pay structure is established compared to having various structures for different groups or different types of positions. One of them being it's the easiest to maintain when you are applying general wage increases or you're making any changes to your structure. There's only one. In addition to that, it'll also assist with pay equity compliance. So one thing to note is that base pay structure development should be based on the organization's mission and the compensation philosophy. So what is the actual base pay structure? So the backbone of the creation of the base pay structure is usually a predicted pay line that's created by conducting a linear regression between two variables. And that will be those job evaluation points that were established, and then wages. You can either utilize internal or external. So internal is you can use your organization's current wages, versus external will be any market wages that may have been collected through your analysis. And then there's a predicted pay line that is used to establish the structure's pay ranges, job evaluation point ranges, and pay grades. So each pay grade within the structure should allow movement within that range. The structure usually contains a maximum pay rate for each pay grade set based on that predicted pay line. And then there is a minimum wage range that is set based on a portion of that maximum range. So again, going back to that competitive, what do we need in order for our structure to be competitive? A competitive structure encourages the improved performance, and it motivates your employees to develop their capabilities and competencies. It provides sufficient flexibility to accommodate the changing fiscal, economical, marketplace, and internal equity condition. And then it also avoids internal compression of wages between other positions within your hierarchy. And we need to ensure that there's meaningful differences in pay based on those job evaluation points that are established for each position. So continuing on what we need for an effective structure will allow the entity to provide across the board increases, and those increases should be set at a rate based on what the market is increasing. So following what those market trends are, that's how you should be able to determine what would be that general increase that should or possibly be applied to. So the across the board increases should be placed on that top annual step wage of each grade, and then all preceding steps should be calculated based on the percentage of the top step established for that base pay structure, and then all the calculations should be rounded to the nearest cent. So provided step increases or movement within the range upon some performance measure, so meaning in the annual step increases or other movements may be awarded each year until that position reaches their maximum range. So now I'm going to hand it over to Brandon. He's going to give us a little bit of a legal wage and hour update.
All right, thank you, Karina, for statistical good stuff. Now, as Karina mentioned, I'll cover legal wage and hour update. Now, of course, what would be in wage and hour update without Fred Flintstone punching his time clock on a stone tablet? So with that segue, what are we going to cover in this part of the presentation? So we're going to cover a few things. One are just what are the basics of legal wage and hour issues, what is the Biden administration looking at, and then cover those 4 subtopics that we talked about earlier. All right, so first, what are just the quick basics? Now, this is not going to be an ad nauseum treatise on FLSA, but we figure what's our core for what we're dealing with. There are really 3 main laws, though there's many others we're dealing with. One is the Federal Fair Labor Standard Act. What's the gist of that law? One requires generally most employees to be paid a minimum wage of $7.25 an hour. 2, it requires overtime pay, or for you as public entities, compensatory time off at time and a half for all overtime hours worked, which for you in the public sector are 2 sets of employees. One is for most employees, it's over 40 hours in a work week, or for those who have public safety, police, other law enforcement, fire, it's the ratio of either for law enforcement of 171 hours and 28 days before they get overtime, or proportion based on we'll talk about your work period, which is an issue, or for fire, it's 212 hours and a 28-day work period. And then 3, it establishes certain wage and hour records be created and maintained. Then on top of that, the often overlooked, but just as relevant body of law is the Minnesota Fair Labor Standard Act. So 1, it requires most employees, but for you in the public sector, there's a lot of carve-outs. So that's why most of you go to presentations, you Google it, you'll get a lot of FLSA and not much MFLSA, but you still will have employees who are also subject to this law. So 1 requires they be paid a minimum wage, which Minnesota law is basically based on an inflationary mark. As in 2021, that's at $10.08 an hour. Now, both with FLSA and MFLSA, there are certain twists and turns and exceptions where you can pay certain employees less than that, but these are the core minimum wages. 2, like the FLSA, it requires overtime or compensatory time off for all overtime hours worked. But the overtime hour threshold under Minnesota law is 48 hours in a work week for anyone the law applies to. And again, like the FLSA, requires certain wage and hour records be created and maintained. Then the other new law that is fairly extensive and is causing a lot of administrative work for all of you at the front lines, and that's Minnesota's wage theft law. Now, though that law was called that, that's a little bit of a misnomer because it just doesn't deal with wage thefts. It deals with a lot of other record-keeping items. But basically, what does this law do, which is spread throughout different laws with the Minnesota statute? It establishes certain wage and hour payments, when they should be made, how they should be made, establish certain you-give, which is causing all of you a lot of administrative work, certain hire and earnings notices to employees and applicants that you want to hire. 3, it establishes certain record keeping that you have to engage in. 4, it provides protections for employees. 5, it establishes certain penalties for those who engage in wage theft. And 6, it establishes certain enforcement mechanisms. So again, that's a law will, basically is trickled throughout this presentation. Then, of course, there are a lot of other laws, a lot of them in Minnesota law relating to minors, to leaves, and to payroll deductions. So those are the 4 main laws, 2 FLSA, 1 Minnesota wage theft, and then the other miscellaneous. Now, we already got one question in advance is, why is this a big deal? Not only just because we're all in the HR world and we love it, but how do you tell others it's a big deal when compliance costs a lot of time, expense, and effort? So we basically have 2 slides. Collectively, if you look at FLSA and Minnesota wage theft law, if we muck up in one of those bodies of law, here are certain things you could be subject to. 1 is federal state government investigations. 2 is paying unpaid minimum wage or overtime compensation, plus an additional amount equal to that in what's called liquidated damages. So in the legal world, we call it double damages, compensatory damages for any employees who've suffered other damages. 4 is a compliance order in state court or federal court. 5 is an injunctive action, which basically says, don't mess up again, or there could be problems. 6, cost disbursements, witness fees, attorney's fees. 7, you could obviously be in litigation or some other administrative hearing. 8, there's monetary liability overall. And what we're talking about is clearly compounded because wage and hour law is one of those laws. It's not just going to generally be one employee making a complaint or filing a lawsuit. It's generally going to be a class of similarly situated employees. Now, where we're seeing an uptick, as we'll talk about, is in the law enforcement world. So you have a bunch of patrol officers feel they weren't paid overtime. They'll collectively could come together, and that ups the ante of how much you have to pay. Then the other liability we have, once we get to that slide, involves under Minnesota's wage theft law. And that is there's civil penalties if there's an intent to defraud and not pay people the wages they're owed, equal to their average daily wages. There's also up to a $5,000 penalty for repeated failures. There's also, if you engage in willful or repeated violation, there's a fine up to $10,000 or imprisonment of up to 6 months. And then there's also imprisonment of 1 to 20 years under wage theft law, and fines ranging from 1 to 100,000, depending on the amount of wages stolen. Now, thankfully, you as public employers weren't the impetus for this wage theft law. So it sounds harsh, but hey, this is just the law. These are the fines, these are the civil penalties subject to imprisonment, but you're seeing a lot more in the construction world. But hey, it's still a body law we got to be cognizant of and obviously not violate. And then timing, what's the general timing, especially under FLSA and MFLSA? 1, it's 2 years from the date going backwards from someone complained, and 3, if it's willful. I know we've gone through other local governments where we may have an FLSA complaint. So, you know, the general look back period usually will go 2 years because the general proposition, you know, honest mistakes, not willful, but if proven, you'd have to go back 3 years. So with that said, in the past 5 years, have any of you received a complaint from employees that you've not appropriately compensated them for FLSA overtime pay? So survey says, all right, so only a scant 7% of you. Now, I do think that's going to change in the future because I think under the Biden administration, we'll talk about next, you're going to have upping the staffing at U.S. Department of Labor and upping the focus and therefore the information that goes out to employees. So if you haven't been dinged with a concern or complaint yet, that's going to be a lot more probable in the future. So now what are the trending topics here? So let's try to distill what's the Biden administration looking at in the wage and hour area. 1, they've already started the process and put on hold changes to rules related to FLSA exempt employees and independent contractors that we'll talk about. So the Trump administration tried to make them more employer friendly. Now with the Biden administration, they're probably going to tilt back towards being more employee friendly with the rules. Secondly, we just think overall, though we don't know exactly where the rules will go, you'll see a lot more scrutiny of whether or not you're appropriately paying, especially overtime pay for you as public employer. So what's the quick checklist? Revisit your overtime standards. Which is, what the Biden administration will do, especially what they're going to look at is technology. Trump administration started some of that rulemaking, didn't get very far. Biden administration is going to focus a lot more on what they call off the clock work. You know, your patrol officer, you email them asking about a case, they're off duty, they're checking email from home, takes 2 minutes. Is that now going to be something that's going to get more scrutiny and we should be recording this time? We'll talk about that. Also reviewing FLSA exemptions. You know, who you claiming is salaried and not subject to minimum wage, but more specifically overtime. So they'll scrutinize that with potentially rule changes. So overall, then they'll coordinate a lot more with our state for Minnesota's Department of Labor and Industry. And you probably heard, obviously, though it didn't make the final bill, with the COVID relief plan, the Biden administration was looking to raise the federal minimum wage to $15 an hour. Didn't get anywhere. It could be tough with the current political makeup, but something we'll continually hear. So now, substantively, what are things you need to have on the radar? First, let's look at, as Karina mentioned, our FLSA exempt status. We're going to get a lot more scrutiny in full circle to distill. These are employees you claim, again, are not subject to overtime and or any of the record keeping under FLSA or MFLSA. So quickly, how do we make sure they're right? 1, go through the job analysis Karina mentioned, get them in job descriptions, do your analysis to make sure they're exempt, and we have the paper trail to prove it. But what are the 6 things you can look at to make people exempt? There's called the executive, the administrative, professional, and instead of executive, the 4th sub-bullet should say professional. Then we have the computer under FLSA, though not recognized by Minnesota law. Then we have the highly compensated employees. So those are all exemptions that you should specify those duties to make sure we meet the exemptions. Literally use the language of FLSA as we do when we go through our local governments with that right in the job description. So what are two standards you have to meet to make sure they're exempt? One, you got to pay them a salary. Two, they have to meet certain duties tests we talked about. So quickly, salary, all right, most of you, obviously, these are lower paid employees, or excuse me, the threshold is low. So if you're paying somebody over $35,000 a year, you're going to meet the salary threshold. So for most of you, that's easy for your exemptions. But what we have to make sure is we're regular paying somebody the salary at each pay period right out of the federal regulations. And two is we're not subject to some reduction because of variations in quality or quantity of work. As we'll talk about at the end of this, you can pay FLSA exempt employees more than their salary, but you always have to pay them the core. Two is a general proposition. A lot of exceptions we've talked about in prior webinars. You can reduce it, but rarely can you ever do that. So, executive, these are your pot of options to look at to get someone classified as FLSA exempt, including your job description. So there's executive, which means their primary duty, meaning the core of their job is to manage an enterprise of a recognized department or subdivision of your entity. They regularly direct the work of two or more other employees. And three, they have real authority to either undertake or at least effectively recommend. That is, if you recommend these things, you give a lot of weight to them on hiring, firing, advancement, et cetera, of employees. So those are the three standards that have to be met to be executive. Administrative is the other option, and that is they generally do office work, but it directly relates to the management of your business operations. So it's not per se just important to your community, but it's per se important for you to function as a local government or state government or educational institution. And secondly, they've got discretion and independent judgment. So it's not just are they doing these things, generally they can do them with maybe some checks and balances, but bottom line, nobody's really scrutinizing their work. They have authority to actually judge and do things. Third is professional. And again, this is where there's two. There's the learned professional, which is more relevant to public sector. Creative, it's very rare to have that exemption met. But learned professional means you've got someone who requires advanced knowledge in a field of science or learning that's generally acquired by a prolonged course of specialized intellectual instruction. So if you look at your engineers, if you look at your folks, some in your park systems or your public health subdivisions of your local governments, those are people who we can maybe get the learned professional exemption. So the fourth exemption is computer. These are more your techies. Now, this is one that we've just inordinately been dealing a lot more with, just because, hey, as technology's evolved, use local governments have evolved. So this exemption, even if they're not going to meet the others because, they're standalone individuals, but if they're doing a lot of this computer work where they're developing things for you and modifying systems, your IT people, your IS folks. Now, but I will say this, a lot of your IS IT folks are on the bubble. So let's make sure we go through this checklist to make sure they meet that exemption. But there's a little nuance with computer folks that you don't per se have to pay them a salary. Instead, if you don't pay them a salary, you can just pay them hourly, but at least it has to be $27.63 an hour. So that's the nuance with computer, but let's be careful. But hey, it is an exemption you can use. Another exemption is highly compensated. So that is employees. Maybe they don't meet all the duties being primary or core of their job, but do they customarily and regularly perform one of those executive, administrative, or professional duties we talked about? Now, to meet this, though, they have to be paid total annual compensation of $107,000. Now, it gets nuanced. What does compensation mean? Generally, it's just going to be your direct cash payments, not monetary benefits, but you can bounce things off if you give differentials. So if you're paying someone at least $107,000 and at least they customarily and regularly perform one of those exempt duties, even if it's not their primary. However, primarily they must be obviously an office person, a non-manual person, then they can potentially meet this exemption. Now, recently, even under the Trump administration, that amount was raised, the highly compensated. So that's today's dollars, $107,000. Now, another issue that comes up with our local governments, or if we look at, for example, cities with municipal golf courses, we want to have, which is a perfect example. We want to compete with the private sector because, hey, it's golf. So to bring in a hired gun, it may be tough for us to treat them as a ho-hum employee, treat them under the base pay structure that Karina talked about. They often like a lot more performance pay. They also like the liberality of working with vendors, which is unique and more of an enterprise, more of a business for local government. So we try to get them classified as independent contractors. But now we've got to be very careful and cautious. And I'm going to throw this out there. It's going to be excruciatingly difficult for any of you to get your individuals who perform a core function, or, for example, back to the golf course, a full separate standalone enterprise. If they're performing something so important and at the core of who you are, it's now going to be tough, especially under a Biden administration, to get them classified as independent contractors. So what does that mean? You're going to be subject to employment laws. You're going to be subject to paying them overtime unless they're salary to meet one of these other standards. So what we've laid out, though the Biden administration has unequivocally said they're going to take a relook at these factors we're talking about. So all we can say is, as of April 20th, here are the factors. So there's about 7 factors that arise from case law. What's at the core of these is summarized in Minnesota law. Generally, they've got to bring their own stuff to the table, be it equipment, technology, which is, you can tell, tough, for example, with a golf course. And 2 is they generally get to call the shots. So the more you control this individual and tell them what to do and how to do it, the substantially less likelihood you're going to ever be able to get them classified as an independent contractor. So then you say, well, practically, great. What do we do about it for those people who maybe don't quite fit and they're sort of a wonky employee if they were deemed an employee? We are doing a little more, though it's not always generally recommended, employment agreements with these employees. And within those employment agreements, so you have to be cautious with your overall system and even with pay equity law, which is an issue with these people, we can look at more performance pay. So we get it. Some of you have performance pay, some have performance pay light, some have none at all, and it's tough in the public sector. But what we can look at for these people you'd otherwise want independent contractor, maybe we could do carve-outs without setting a precedence to do more of a performance pay for these individuals. But full circle, legally, this is clearly in a Biden administration agenda item that they're going to go after. Then we look at not only, now we've talked about exemptions and exclusions, but now let's talk about when it comes to paying employees for time worked. And it sounds innocuous and easy, but for all those who've gone through the FLSA audit and review exercise with us, this can be painful, but it's important, and you're likely going to be a lot more scrutinized. And overall, we're practically seeing a little more complaints and concerns from employees, especially in the public safety world. So what does this mean? What do we have to be on guard for? 1, we have to make sure to compensate. Generally, the law is clear. You compensate in cash. Unequivocally, if you work time for us, you got to be paying us cash. So unless it's overtime, generally that means you can't even do comp time. And we see that in a lot in public safety, for example, and I've highlighted the training one. Under law, it says, we have to compensate, and they count as overtime all time during which an employee is on your premises or on duty. And within FLSA, there's a lot of carve-outs that talks about when you're in training, generally, and it's for us as the employer, that's going to count as on duty. We generally have to compensate those employees, generally with cash, or they just have to be at a certain place. So what doesn't include, so we don't have to pay for it, we don't have to count it for overtime. That is, 1, it's paid leave time, or 2, minimum hours of pay for time not actually worked. So when does that happen for a lot of you? A lot of you in labor contracts have callback provisions. So it says basically, if we call you back after hours, a lot of you have provisions that say we'll pay you a minimum of 4 hours at time and a half pay. So if the employee just works 2 hours, the 2 hours have to be compensated under law, not just contract, and count towards overtime. But that extra 2 hours of pay you give them, because it was not for time worked, you generally don't have to count that, as we'll talk about later on, as time worked or in overtime pay. So overall, what's the pointer from all this? This is why it's much more important for all of you to scour and make sure your timekeeping policy is in good place and clear, what time is recorded, how they do it, and the presumption is if you don't record it, we're going to assume you didn't work. And two is their actual recording of actual time worked is key. Now, a lot of you have been through the seminars. We've been saying this for years. Make sure when employees fill out your a lot more, you going to the electronic timesheet or the timekeeping system you have, make sure they're recording actual hours worked. So if they work a callback of 2 hours, make sure they're recording 2 hours as callback. Make sure they're not recording the 4 hours of callback pay you say you're going to give them under contract. So it sounds elementary, but it's going to be a big deal, as we'll talk about later, to maintain compliance with the law, not only for record keeping, but maintain compliance with counting overtime hours, and 3, making sure we're appropriately paying people. So what are some of the hot topics? So what I've done here, I've summarized the law. So here's the question we get a lot is an employee later claims, hey, I've been checking emails after work. I didn't record this time work because your policy said don't do it. You didn't encourage me to do it. But if you as an employer know somebody's working, for example, off duty, checking emails or taking phone calls, or you at least have a reason to know it, then it has to be deemed as time worked, subject to minimum wage, overtime laws, and record keeping laws that we're talking about. Even if you didn't ask them to check emails, even if you weren't the one as management to call up the sergeant after hours as a patrol officer and say, hey, you responded to this incident, can you give me the 15-minute nutshell? So then that sergeant spends 15 minutes after hours. Even if you didn't ask for it, even if you didn't directly authorize it, generally if you know that's happening, you're going to be subject in the laws that we put under there as having to pay for it and count it as towards overtime calculations, and 3, do your record keeping. Now, related to that, there used to be pre-technology, much more of a carve out before smartphones, laptops, cell phones, etc. There was what was called the de minimis exception to the law. Again, from my sphere, we get a lot of these questions in law enforcement. The sergeant spent 3 minutes telling a patrol officer, and maybe they're an hourly sergeant, some of you they're not, a lot of you they are, saying, all right, here's a 3-minute nutshell of what happened in this incident. So if it was 3 minutes, is beyond their work hours, didn't happen a lot, wasn't substantial, he wasn't doing this every day, every week, etc. And it was just tough for us to track 3 minutes of time. If those 4 things were met, maybe we don't have to treat that 3-minute response off duty by the sergeant as time work. However, courts and opinions are now shifting and saying, well, hang on, we've got technology, you know it, you're encouraging it, even if it's not local government provided, even their own. And by the way, you have these great payroll software. By the way, you can easily flip a switch and much more easily account for 3 hours and pay for it than you could in the past. So now there is more litigation, especially in the public safety world, where employees, if that sergeant is spending 3 minutes every week, 3 times 4 is 12 minutes a month, times 12 months, that's 144 minutes, 2 hours of pay that 1, we should have been paying, 2, should have counted towards overtime. So now you see why there's even much more of an economic interest for law enforcement to say, hey, pay up, especially when they know economically and their lawyers know you could get double damages and be on the hook for attorney's fees, etc. So those 3-minute calls used to sound innocuous, but not in the heyday of smartphones, laptops, etc., that you know about, and you know these calls are happening. So what do we do about it at the end here? One, and again, these are policy decisions where even local governments are split on this, or educational institutions, or the state. Let's have a policy to talk about, all right, do we want to carte blanche say, bottom line, if you're off duty, don't do anything for us? Or is it a hybrid? By the way, certain employees can do certain things off duty, but just so we know we're complying and making sure we're paying you appropriately, you got to record that time work. Now, I had one other local government say, well, if you encourage them to record a time work, we're going to be on the hook collectively for those 3-minute calls over the years that we weren't otherwise. True, but I'm saying if you knew about it, you should have them record it, so at least we can comply with record keeping and overtime minimum wage laws. So bottom line, there's no clean-cut, nice policy that talks about off-duty work. This is a real local government-specific decision. Then what you have to do, we get the concerns. Well, hey, I didn't know that sergeant was taking, the 15-minute calls over a month time frame, one 15-minute call a week over a month. So then we say, all right, if you know about it, we're going to have him record it, he or she, and pay for it and count it towards overtime. But here's what you should do. If you had a policy that said they should not have been responding for 15 minutes off duty, we can discipline them for not following a standard. But what we can't do, because it's too legally dicey, is withhold his or her wages. So it's one of those, sin no more going forward, but pay up. Another issue we get related to the 3-minute call is rounding. Here's what you need to do. Now, some of you have it in place in practice, but get your policy. And here's what we mean by that is Fair Labor Standard Act allows you to round time to the nearest, for example, 15 minutes, which we think is the easiest. So what does that mean? You can round time downwards for employees. So for example, a lot of you have 15-minute increments that you pay and record time on. So then again, which we think is going to be the legally most palatable, you can have the 7.5-minute cutoff. So if someone works less than 7.5 minutes, you can round down. But what you always have to do, of course, if they work 7.5 minutes or more, you've got to round up to 15 minutes and pay for them. So the bottom line, you're going to be best positioned if you have a policy in practice that talks about how you round. Now, what the courts have said, even in the circuit here, our Federal Circuit Court of Appeals, is great if you have a policy, but we need to make sure if someone complains that it doesn't disproportionately always end up in a lot of people getting rounded downwards and not getting pay or having that time count towards FLSA overtime. So 1, have the policy, 2, have the practice, 3, let's do a review just to make sure it just mathematically doesn't end up in everybody being rounded down and not being paid. So based on that, do you have a policy or procedure for employees performing any work off duty and recording such time? Survey says. So no, so about 80% of you. So hey, at least if we get one thing out of the webinar, let's get a good off timekeeping policy and let's get a good off-duty policy in place. Now again, some of you it's the double-edged sword. By establishing a policy, you're basically encouraging it, but then we have to recognize practical reality. You all have to think, especially with the subgroups of employees, maybe you do want that sergeant responding. Maybe you want the assistant city engineer who maybe is paid hourly to be responding to things if we've got flood. So let's review policies. Now we shift gears to minimum wage. So what's the gist of that? Obvious, okay, we got to pay $7.25 an hour. Unless the employee is covered by MFLSA, then we got to pay that higher wage. Worked in work weeks or in periods in which FLSA overtime hours are not worked. So what does that mean? Put aside your contract, policy, etc. The law requires cash payment for any time worked, and we'll talk about what happens in FLSA overtime periods at a cash of $7.25 an hour. Now, some of you accidentally and by default, maybe for training, for example, is a prevalent one we see. It says if an officer, again, law enforcement where it's most prevalent, just gets an hour of compensatory time for time spent at training in lieu of cash. Well, on its face, we got a real problem with that legally to meet minimum wage. But some of you maybe accidentally have complied with minimum wage law because maybe if you take their total earnings, which the law allows, and divide it by their hours worked, so as long as we're counting those hours, you probably, with their higher wages, have it equivalently paid them $7.25 an hour. But where we are seeing the issue when you, for example, give an hour of comp time for attending training in lieu of cash is not counting those hours for overtime, which you have to. So that's much more the flaw. But again, all this can be superseded by your labor contract or past practice because maybe you obviously pay more generally for higher level employees than $7.25. You still got to stick with that. Put aside law, labor contract and past practice may require you to pay more and to pay for more hours. So again, what does it do? You got to pay straight time rate in cash for each hour worked in work periods. Let me do a quick side note. If an individual works FLSA overtime on the second bullet, that is over 40 in a work week, or for law enforcement or fire, a different work period, you have to pay them not just the minimum wage under FLSA law, but you have to pay them the straight time rate for each hour work. So they want to make sure before we calculate overtime, you've made them whole and pay them everything you've committed to in policy, contract, or practice. So that's in. Now let's shift gears from what's compensable to what are overtime issues that we see. One is in public safety. As we talked about, there's a carve out for overtime that for law enforcement, you have to pay in 171 hours every 28 days, or if your work period's different, the proportional amount, or for fire, it's 212. So what is a work period that's important here? It sounds innocuous, but important and often overlooked. So we need three things. What's a work period? It has to be an established and regularly recurring period of either 7 through 28 days. Again, this is for law enforcement. You don't need to base it on pay periods, though a lot do, but some don't for mathematical formulaic reasons or based on work schedules. And it can be different for your employee groups, but it has to be established and regularly recurring. Two, you can change it, but only if you're going to make a permanent change. So what we can't do is flip the switch and change our work period from 7 to 14 days just to minimize overtime in certain, intermittently. Instead, you have to go, if we're going to switch from 7 to 14 days, it's got to be a little more permanent basis. And two is you're not just doing to evade overtime compensation. So this is right in the regulation. Then three, the biggest innocuously overlooked one is you need a notation somewhere. Generally, it's best in your, for example, your timekeeping policy and or your police or fire department, subject to HR oversight and administration, in those departments' policies and or guidelines that says, here's our work period, and here's the time of day, here's the beginning and end of that work period. So again, we need to have that work period well documented because that's right in the law. Generally, it's best through a timekeeping policy, HR memo, or department policies or guidelines. So are you aware, do you document where you have public safety departments' work periods described for FLSA overtime periods? Do you have that documented? So yes, good. Looks like close to 3/4 of you do have that documented. So then we'll shift gears to next slide. Now let's talk about the calculation. Now, what I'm going to do, it's not just a primer, snoozeville to have to sit through it, but I'll try to weave in where we see problems when it comes to calculating appropriately FLSA overtime. So first, what's the first thing you do? You first say, all right, even if someone worked Fair Labor Standard Act overtime over 40 in a work week, or for public safety, their relevant work period, let's calculate all their contract, policy, or practice pay they get. Just put FLSA overtime in a box, just run the numbers, what do they get? And when I say what do they get, meaning even if they get callback pay or they get night shift differential, lump all that money into a pool, let's calculate that and make sure we're paying them back, or excuse me, paying them that. Then we can finally get to, all right, do we owe them any cash FLSA overtime payment? So again, that's often an oversight. Employers, sometimes we get confusion when you try to do all this calculation at once. Instead, we sort of need the demarcation. It seems inefficient, but one, it's the only way to appropriately calculate it. And two, for those who've gone through a painful exercise, if we have to go to the U.S. Department of Labor, which is more prevalent on this issue than the Department of Labor and Industry, we want to have our calculation broken out. Again, even if it seems inefficient, if you can set it up in your software program or set it up in a spreadsheet, one, we can properly calculate, and two, we can easily show if it's complained about how we're calculating it. So innocuous elementary start, but an important start how we get to FLSA overtime. Now, again, I get it. A lot of you should have it in autopilot, but some don't. Then we get to the next part of overtime. And then what do we do now to calculate it? This is where we start to get nuanced. And we go, first I said, all right, let's calculate everybody's total gross pay. What should we give them? But now we have to get to, if someone worked FLSA overtime, what's the regular rate of pay? So this is the core issue that we're getting at for basing overtime. What do you include initially when we first do the first step, calculating gross earnings. So you look at all wages they get, even for overtime hours in contract. For now, we lump them in. Or specialty payments. Do they get night shift differential? Or do they get standby pay or on-call pay? So you lump it in and first go, all right, everything's included. But now what we do to calculate regular rate for overtime purposes, what do we exclude? First, we exclude, did you pay him for any paid leave time? All right, let's take that from our gross earnings. That's not going to be included. So it's either excluded or subtracted. Then we look at how much we pitch in for benefits. We know we're not going to include that in gross earnings for employee. What else do we exclude? What's the third pot? Other pay above base pay, not for hours worked. So back to my example. If we gave somebody callback pay, remember, this is where we get back to, we paid them a minimum of 4 hours for working a callback, but they only work 2. So what can we do? We can exclude from the regular rate of pay, and initially here our gross earnings, we can exclude those 2 hours of callback that we paid them for at that rate, but they did not actually work it. So that's an example of other pay that you either subtract or you can talk about excluding from our initial step of calculating regular rate. What's the fourth pot you can exclude? If somebody gets, it's the specific premium pay amount that's at least a half times above their base pay. So what does that mean? A lot of you have contract provisions. If you work over 8 in a day, you get time and a half. So what can we exclude? We can't exclude from gross earnings the straight time they got, but we can exclude that extra half time by contract you'd said you'd get them. So if they work 9 hours and we pay them time and a half for that under your labor contract, we can exclude from gross earnings for regular rate calculations that extra half pay. Or working over 40 hours in a work week, or other period for law enforcement, or somehow over their normal working hours or regular working hours. Now the fifth pot, though it's still premium pay, it's going to be relevant later on. The fifth pot of exclusions from gross earnings, again, it's premium pay at least a half times above their base pay. So if you give it for Saturdays, Sundays, a lot of you have it for holidays, you maybe have double time. So what does that mean? If it's double time for working holidays and you pay them for 1 hour, you have to include the 1 hour straight time pay in this calculation, but you can exclude that extra hour pay that you gave them as premium pay. So that's the fifth pot of exclusions from gross earnings. So now we've got step one. We've calculated what gross earnings are included in the regular rate of pay. Now, one thing I want to clarify, remember, we have to lump in all those gross earnings. So whether it's for training, whether it's for a callback, that's sometimes the hiccup we see with this, is not lumping in all the cash generally they get, even standby pay, or some of you call it on-call pay. So let's make sure we get our gross earnings right, because sometimes that's where we do see the hiccup. Then what we have to do to figure out the regular rate of pay, next step is divide it by actual hours the person worked. This is what's going to be called your regular rate of pay under FLSA and MFLSA. Now, actual hours worked is important here because we divide it by any physical hours that they worked. What you don't do is divide it by that paid leave time, the sick leave time that they were off. For example, back to the callback pay. If you paid them 4 hours, but they only worked 2, and this actual hours worked, we're only including the 2 hours pay. So all these examples I brought up are real world examples that we get brought to us and we work with local governments on. Then you've got the regular rate of pay. So if we know they worked FLSA overtime hours, what we have to do is multiply that regular rate by a half. So if our regular rate of pay is $20 based on this calculation, their actual regular rate of pay for FLSA purposes is going to be $10 an hour. Then we take that $10 an hour and multiply it by their overtime hours worked. Now remember, what we talked about is what count towards overtime. That's why we started out with the compensable hours worked. So that's a big deal that we make sure when we're calculating overtime, we're still counting that training pay or that time they attend training. We're still counting the callback and the 2 hours that they worked. We're excluding the 2 hours extra they're paid, but we're still including 2 hours worked for overtime. So you take the $10 regular rate multiplied by hours worked. So then that, as you know, based on your software system, a lot of you have, based on your portal, based on your spreadsheet, you look at that and go, all right, that's how much additional pay we have to owe them above the gross pay we started with as FLSA overtime. But then what FLSA overtime law says is, let's say we had regular rate of pay of $10. Somebody worked 10 hours of overtime. Generally, that'd be $100 we owe them under Fair Labor Standard Act overtime. But what FLSA law says we can do, which you should set up in your software system or portal or spreadsheet, is you can deduct the 3 premium pays amounts that are listed right here. So any premium pays that is a half time above their base pay that we paid, we can deduct those dollars. So what does that mean for a lot of you local governments? You've gone through this, chances are, again, working with, I'll rough it, 95% of our local governments, or we scour this, you're not doing probably something right technically within this. But here's the issue. You may have accidentally been compliant with FLSA overtime based on this deduction. What do I mean by that? A lot of you pay, for example, time and a half for hours worked over 8, or for law enforcement, their period. So you're already paying the premium pay. So even if you didn't do this calculation, you probably kind of maybe have been complying with FLSA by not knowing it. But obviously as lawyers, we have to say, okay, that maybe was a consequence, it was accidental, but going forward, we got to fix it and utilize, I know it can sound rigid, but it is the way you need to do it. And I do want to clarify, a question came in that talked about, well, do you count in gross pay, paid leave time? Again, no, you don't count paid leave hours or paid leave time, or excuse me, paid leave pay in this gross earnings or hours calculation in FLSA. So if it's paid time off, sick, vacation, etc., you don't include, you put your blinders on in everything we're talking about and calculating FLSA overtime. So again, where do we see a lot of the hiccups? Not counting a big one in law enforcement, or another one we see is specialty pay. You've got a school resource officer, you pay them an extra $1 an hour. Maybe we're just paying that $1 an hour, but we weren't included in their regular rate of pay. It is something that should be included as part of their overall gross earnings that we talked about, you should be paying. So again, a snoozer to listen to this in a webinar, see it in a PowerPoint, but we work with our local governments to set up spreadsheets and the like to make sure they can comply. Then we'll shift gears to talk about compensatory time, which all you can offer. So based on this, all these technical FLSA overtime calculation requirements, are you now confident that your method, your payroll program software for determining FSLA payments is complete and accurate? So survey says your names won't be tied to this. You shall remain anonymous. All right, survey says, well, not surprising, but you're more compliant than maybe we'd expect. About 56% of you think, now, based on this, looks like we're not quite exactly doing it right. But for those 44%, solid, you're in good shape, but always good to do a reminder. Now, we talked about cash and money and wages, but of course, the exception in the public sector is, in lieu of, again, all we're focused on right now, the law does not say you can pay compensatory time off, which we've seen, which causes major legal issues for straight time. But you can pay it for overtime, and we'll talk about those requirements, where in lieu of paying somebody the time and a half for working Fair Labor Standard Act overtime, you can instead just give them compensatory time off hours at time and a half. So what are some of the oversights but requirements? One, for unionized employees, we need a collective bargaining agreement, memorandum of understanding, or any other agreement between the public entity and representatives of the employees. For non-union, we need an agreement of understanding, which is rare, though that's the term of art in the law. We've construed it, if you have a personnel policy, and that, in our view, meets the understanding requirement. So if you want it for non-union, put it generally for most of our entities as right in their personnel policies as part of their compensation or overtime provisions. Now, if they accrue Fair Labor Standard Act overtime hours in their bank, under law, they are permitted to use it, so as long as it meets 2 standards. One, it's within a reasonable period after they ask for it, and 2, it doesn't unduly disrupt operations. Now, we've had some issues, especially in law enforcement, where chief says or sheriff says, come on, we can't be using comp time. It's the busy season, it's holiday weekend, July 4th up north. We can't have you taken off. So we say, okay, sounds good, but if it's FLSA comp time and not separate non-FLSA comp time, can you prove to us if that deputy or if that officer is going to take FLSA comp time off, that's going to unduly disrupt operations? So, the burden shifts to you, unlike most other leave requests, as employers to prove why they shouldn't be able to take it if that's something you're concerned about. So what are best practices? Let's establish management must approve its earning and usage. Here's what we do see, but aren't a big fan of. An officer said, even though some of you do allow this in your contract, says, you know what, I logged in 10 hours of overtime this work period. I'm just going to make that all comp time off. I'm just going to put in the category comp time off in my timesheet, and there it goes, it's my decision. So let's make sure we got a policy and practice and your timesheets are clear, that in the end, management's going to have to prove whether, one, you earn it, and as we talked about, two, whether or not you're able to use it. Now, for a lot of folks, this becomes a big savings account. So a lot of you honed in on, again, I don't know how many chiefs come to us with comp time and say, hey, this is getting out of control, we got to find caps. So do what you can to limit not how much they earn, and or make sure we have some cash out of it if they've exceeded what is your comfort zone and you don't have a hardline cap of how much they can earn. And when we say earn, make sure it's not just an accumulation, but if you're really concerned about how much they stockpile, make sure you specify how much they can earn in a year. Not just, for example, they get to accumulate 80 hours. Because if you have that, remember, an officer can accumulate 80, use 40, but then reboot in that same year and reaccumulate 40 hours. So if you're really concerned about 80 hours, try to get language in policy or contract or understanding that says they can only earn 80 hours within a calendar year, for example. And as we talked about, allow for cash outs, because if you allow them to have carryover of comp time, and you giving wage increases will make comp time cash outs later when they want to use it more expensive. Now, a lot of you, obviously, in the public sector have what we call non-FLSA overtime. We talked about it, those premium pays. If you work in excess of your shift or a work week or other work period or holidays or weekends or nights, you get extra premium pay. But one thing we, notice when we come to public safety, you've got your law enforcement working more than 2,080 hours in a year. You got firefighters working more. Let's clarify, if they work overtime, is it based on the lower rate, effective hourly rate they have, based on their salary divided by, for example, a prevalent one in fire is 2,012 hours, and that's their overtime rate for the labor contract? Or is it based on, like everybody else, the 2,080 hourly rate, which of course can make your overtime for public safety a lot more expensive if you base it on their 2,080 hour overtime rate. So let's make sure we've got that clear in policy and or contract language for unionized employees, what our hourly rate is based on for overtime purposes, excluding FLSA overtime, but focused on, for example, as we call it, labor contract overtime. Now, we've talked about wages, we've talked about overtime and hours. What are record keeping? To me, this is not just, well, administratively, here's what you have to do, but this is relevant to not only make sure we're doing it right, but it's also relevant if a complaint is raised, that we've got a great electronic trail to prove up why we paid what we did and why we calculated or excluded certain hours from overtime pay. So first, what do you need? Hours worked each workday. And we underline the word worked as important under FLSA and MFLSA. Again, I'm back to the callback. Make sure employees who go on a callback, they go to the wastewater treatment plant. If they spend 2 hours, but you pay them for 4 under the contract, make sure they're only recording their timesheet 2 hours worked, because eventually we're going to need to know for overtime purposes, minimum wage purposes, and just to comply with the law generally, just physically, how much time do they actually work? Then we also need total hours and worked each work week. We need beginning and end times of their work day, their start and stop times under the MFLSA. And MFLSA even gets in the weeds and says we have to designate in writing whether the time was AM or PM. Now, it may sound obvious, but sometimes we don't always see that in the timesheet. I worked 8 to 4. Well, we all know generally for most employees that means 8 a.m. to 4 p.m. But if you're law enforcement, did you mean 8 p.m. to 4 a.m. or 8 a.m. to 4 p.m.? So remember, we're just bringing this up not innocuously, but these are things we've seen and have raised issues and complying with all the body of law that we talked about. Then for certain public employers, though we think it's still a best practice, you either need a signed declaration, and it could be even electronic signature that says to the employee, I affirm that all this information is complete and accurate. And for those who are subject to the law below, that'd be cities, it's subject to penalty of perjury. Now, obviously the law and practices, just about all of you have gone to some more formal electronic system for timekeeping. To comply with this law and to make sure it's accurate, have the employees check a box, have a policy, have it right in your program where they say the same thing they otherwise would have signed off in writing that says, look, I affirm that all this is complete and accurate. And I'm not trying to make a false claim against this public employer for wages that I haven't earned. So have some statement like that. Have a policy that says it to make sure the time you're getting is accurate and reliable. Now, a lot of comes up saying, well, we've got salaried employees that, and I've jumped right to somebody had the question. So here we are, same wavelength here. So if you have an FLSA exempt employee, the issue is, oh boy, we can't have them record time, we can't have them track it. Not only practically do we, allow them more wiggle room, but we're concerned that an FLSA exempt employee is going to track their hours so that they can use it to sue us later to claim they worked a lot of overtime. And back to what I said, the Biden administration will put a radar on your mid-level managers if they're truly FLSA exempt. They're going to use it against us. But here's where, one, we've cited and quoted the law, which we think says it best under the Federal Register. When the U.S. Department of Labor changed the regulations back in 2004, they had sort of a preamble where concerns were raised about this. And here's what they said. By having, one, legally having your FLSA exempt employees record and track hours does not in of itself violate the law. You're only going to have a problem with FLSA exempt employees is if you adjust their salary based on hours worked. So we all know you can't do that, but they said, no, one, you can record and track hours, and two, what's the policy? So you can assess their productivity and dependability and accurately account for their leave time. So not only does the law say that in the preamble, we think overall that's good policy and practice. Again, we all get the concern, our parks director, we don't exactly know where they are for the summer season. We think they're doing good work, but I don't know. We're hearing some scuttlebutt from our park maintenance crew that the park director or superintendent is incognito. We don't know where they're at. So our view is get proactive and at least have for FLSA exempt employees log in the amount of hours they work each day. Now, if we got real productivity concerns or dependability concerns, we can have them itemize what they do or be more specific. What core hours were they in, which we still recommend because a lot of you have policies, which is a good practice. Now, we understand you got to have some flexibility for FLSA exempt employees to have some flexibility in scheduling. But a lot of you say, no, if you're office staff in the county government center, or our department's headquarters or city hall, we've got core hours. As a general proposition, we need people accessible in a non-COVID world here in the facility from maybe 9 to 3-ish. Outside of that, you got wiggle room, you're attending meetings, but we generally need you here. So that's why you may not only want to have just how many hours they gobbed in, but what times they were in. Now, of course, we've all seen it where FLSA exempt employees utilize it. Now, if we want to take the negative route to say, I'm logging in so many hours, I need time off or I need a bump in pay. I'm logging in so many more hours as a sergeant, but look I'm not getting overtime. My patrol officers are. They're making how much as much or more than me by working overtime. Here, I can prove it with hours. We say, yes, be ready for that. But overall, as administration management, this is just a good tool for you to, not only generally hold folks accountable, but see how productive they are and to see how many hours are they logging in? What are they logging in for? What times a day? So overall, it helps going back to even what Karina said with job analysis and job points. This is going to be a good tool. So I know I spent a lot of time on it because, as you can tell, this is just one of those issues that maybe it's not the volume, but those entities we work with it on, we have really healthy, meaty discussions. Now, it can be met with some resistance among, I get it. 90% of you are FLSA exempt, so you got to think it. You've got that personal perspective, but you got to look at overall for the organization. And here's why else it's important, which is really a segue to the next topic, though overlapped, and that is dealing with remote employees. So if we send the message, whether you're not exempt, clearly we need to record hours worked and start and end times. But even if you are exempt and working from home, we still need you accountable for hours. So for FLSA exempt, it's just to determine you're basically doing your job. For non-FLSA exempt working at home, as we wait for the remote work slide to come up, it is going to be your tool in liability to make sure that they're still accounting for their time, regardless of where they perform it. So full circle, you get the gist. As a general proposition, Team Legal, the law we think supports it, and Team Legal supports it for liability, and you as management probably practically to have all employees record their work. So that covers the remote work folks, and there we go. So what else do we need? Establish their work schedule, and then clarify they need to be accessible, when they need to use leave time, specify timekeeping procedures. Now, again, we get it. With FLSA exempt, they may not always like it, but we like to have policies and procedures in place. And again, still say full circle. You've all dealt with it in COVID, but a lot of you go into, like Karina talked about, flex or hybrid scheduling. Make sure they're compliant with all other policies and procedures in practice, especially when it comes to doing work, when they should do it, and how they should account for time. That really, I've tried to sum out in 4 slides, which you've all probably seen treatises on how to mitigate your liability, especially from the wage and hour perspective for remote workers. So we know that was a lot. We know it was dense, and as we said, we'll provide not only the webinar, but the slides on a link that we'll send out to all of you. So we do have some short time. We've got a couple chat questions here. All right, asked about the recording. We do have that covered. We've covered recording hours worked for exempt employees. And something else to have on the radar, obviously not only with these webinars, but especially during COVID, on our Coalition of Greater Minnesota Cities website, some of you asked for samples of various stuff, maybe not specific to your question, but we do have other sample policies, procedures, and checklists for folks to deal with a lot of the labor employment issues we covered, especially with these webinars going back to when COVID started last March. And for those of you who are in Greater Minnesota in a city and either a member or wish to be, we will be having our conference where we'll cover some of this labor employment stuff in Alexandria in late July. And then in addition, we do want to highlight, can't quite get to the slide technologically right now, but on May 25th, we'll sort of have our seasonal capstone labor employment webinar from 10 to 11:30, which will give an update on where's the economy, where are your finances, what's practically happening with wage benefits and other employment issues, and then give a legal update. Because I think by then, we even have a better perspective with the Biden administration, especially with this FLSA stuff, with the OSHA safety issues. Now, especially that he's got finally an agency head that has been appointed who can help implement the Biden administration policies and regulations. So with that said, we're always open. Karina on the classification compensation front, myself and other team labor on the legal and practical side for any questions. 2 things brought up. Talk about paternity leave and how it relates to FMLA and sick or vacation. So when it comes to paternity leave, again, a whole separate body, whole separate topic. Generally, when you have paternity leave, it should run concurrently with FMLA leave and sick and vacation leave if they need payment. So that's our quick gist on that. Another one talks about hazard pay for employees. And whether or not there's expectation to get employees will get a bonus. So 2 things on that. 1, we've heard it. 2 is you can't go retroactive. So generally under Minnesota law, you can't, as a public employer, say, we have federal funds, they worked a lot of hours. So for the hours going backwards, we're going to pay them hazard pay or bonus. Generally, you can't do that. Instead, what you can do is take more of the front door approach and basically say, for some finite time or for some lump sum payment for work going forward, because you still have the COVID effect for using those federal funds, here's what we're going to pay you. So you've got to use federal funds like any other money, unless we see some nuanced law that we're not aware of yet that says you can go retroactive. So bottom line, you're recognizing the hazard going backwards, but you got to pay for work going forwards, even if there's not always that direct nice tie. So that's the hazard pay question. Then there's a question about hard copy time cards and using a time clock. So they asked, should they sign the card? So one, if you're a statutory city, they have to sign the card and affirm. Two, if they're not, we still think it's a best practice that says it's complete and accurate and reliable, subject to penalty of perjury. So they should sign off on all cards. Then the last question here is a best practice to recall non-exempt employees to the office under wage and hours. So full circle. Yeah, we tried to position you to have employees work remotely, wage and hour, and talked about things, but we get it. Productivity wise and tracking their time and appropriately paying them, yes, it's substantially more difficult for employees working from home, especially even if they're logged on. We all know the propensity is, but maybe you got flexibility, but maybe you'll be less flexible post-COVID to dealing with all the issues that may be going on where they're working remotely. So generally, yes, there can be a productivity hit. So again, all you have got to weigh it in the balance. As you can tell, it's tough wage and hour wise, but I will say this, back to what Karina said, back to what I'm saying, practically, I think the studies and what we talked about is right. Practically, employees, even in a post-COVID world, are probably going to expect some more flexibility with scheduling and or working remotely. So you all got to do, not only do you have the infrastructure in place and the policies, but you got to decide the most important thing you should decide, who we talking about, what positions. So put aside Joe Smith, Susie Jones, what positions are going to be amenable to some hybrid or remote work. So I think, yeah, we're right. We're, back in a year when COVID's maybe kind of sort of hopefully in the clear, I still think we're going to be talking remote work in a year and see where it's gone. There'll be a little bit more of a push. You in the public sector, it's tougher to get away with because you need public interfacing people. But again, full circle, much like the private sector, though not as much. Let's get infrastructure policies and analysis in place to determine who you want it done. So again, if you've got updated compensation data, every webinar, we include that. We've got the link on that, and we've updated Coalition website, Coalition Summer Conference, and also the future webinar, and here it is. So we hope to see you in May. If not, hear from you sooner. Karina and I are here to meet your class comp and labor employment needs. So thank you and enjoy the spring snow.